Order, all rise.
Please be seated. All right, Mr. Harpootlian, I believe it's you to present your witness.
Yes, ma'am.
Please be,
Rhonda McElveen. You know how this works?
Sure.
You know how this works?
Yes, I do.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, that's what I'm here for.
Thank you. Please have a seat on the witness stand. State your full name for the record, and please spell your first and last name.
Rhonda McElveen, RHONDA MCELVEEN. You gonna make sure I'm gonna stay here.
Ms. McElveen,
Yes, sir.
say your name for the record again, please, so I can make sure I can hear you.
Rhonda McElveen.
Your Honor, can you hear? Okay.
I can't hear you great, Dick. I can hear you, but I would doubt that anybody posted
That
lawyers
better?
would hear you.
Is that better? No?
Is that thing on, Mr. Bailiff?
I think this is Mike for the other courtroom. It's Mike for the next door.
I don't want to get into the thing going.
Well, I can speak up.
haywire here.
I'll just speak up. How about that? I have a big voice. I'll use it.
It's just not on at all, though.
No, it's all right.
Is it on?
Yes, ma'am.
Okay. All right, Mr. Harpootlian, you may proceed.
I'll speak a little louder if that helps. Say your name again for the record, please.
Rhonda McElveen,
And Ms. McElveen, what do you do for a living?
Clerk of Court and ROD for Barnwell County.
Clerk of court in what?
Register of Deeds, I have 2 titles.
2 titles. And is that an appointed or an elected position?
Elected.
So you're elected by the people of Barnwell County.
Yes, sir.
And how long have you been the clerk of court of Barnwell County?
This is my 16th year,
16 years. And
and I'm running again, sir.
you're up this year, 24 is,
Yes, sir.
all right. Don't think I'm allowed to plug that, but you have been the clerk for 16 years. You're up again this year. Now, do you know the clerk of, well, back up for just a second. Do you hold any position with, is there a state organization of clerks of court?
Yes, sir. I'm actually the president of the South Carolina Clerks of Court and Register of Deeds.
Okay. And that means that of the 46, there are 46 of y'all, is that
Yes,
right?
sir. Yes, sir.
And you were elected to be the chairman of that group,
President of that group.
president of that group.
Yes, sir.
Now, are there certain rules and constraints that clerks should operate under in terms of dealing with juries?
Yes, sir.
And is there training for that, or is there a book for that, or how do you learn that?
You have the Clerk of Court manual for one that's on the judicial website. You also have the law books that have it in there. There's actually 2 separate forms, SCCA 237 and 238 maybe, that has regulations on it. And then we also have in the handbook that, or not handbook, but in the program within the CMS system, they actually have rules and stuff there you can go by as well.
Now, as a clerk of court, are part of your duties to deal with juries?
Yes, sir.
To once, I mean, we understand there's a jury venire that's brought in at the beginning of a term, and then individual juries are picked for both civil and criminal cases. Is that correct?
That is correct, unless it's a non-jury trial.
And then there's just a judge, like we're doing here, right?
Yes, sir.
And in the process of picking juries, do you assist as clerk of court? When I say assist, who actually picks the jurors out of a hat, or however, whatever the process is?
Well, actually, the first process is you draw a jury by computers through the CMS system, and then summons are sent out. And then once we come to court, we usually do a roll call. We see what everybody's doing, what their jobs and everything, to help the attorneys to decide which jurors they would like to get. They have so many strikes, etc. And then you call the names, and they have the strikes, and then that's your jury pool.
And then the judge will seat a jury in a jury box, like, although I've never quite seen a jury box that looks like that, but a jury box in a courtroom, right?
That is correct.
Your jury box in Barnwell County is a little, like 2 rows of 7 or 8 people.
Well, I actually have a jury box on both sides of the courtroom, because I have the grand jury on one side when they convene, and then I have the petit juries on the other side when they convene.
Okay. And the jury, they're sworn by the judge, and then they're put in the jury box, and they begin to hear arguments and testimony and jury charges by the judge. Is that correct?
Well, actually, sir, where we do it, the clerk of court usually swears them in with the judge presiding over the whole deal.
Okay. Once that jury is sworn in, what is your role in terms of dealing with those jurors individually or as a group? Are you allowed to talk to them individually, to pull them out, to converse with them about your opinion about the case?
To pull them out of the trial while we're going on?
Yes, ma'am.
No, sir, we're not. If they're on a break, etc., or if they request to see someone, then we manage to, I'll go in the door open, I'll say, which one of you needs to see someone? It might be the judge. And I said, hold on, and then I go get my judge. And so we've got a juror that needs to speak with you.
Do you converse with jurors about the merits of the case? By the merits, whether someone's guilty or innocent, or whether a plaintiff or a defendant should win in a civil case? Do you ever do that?
No, sir, about the most, only thing I ever do is go in and count them and tell them I can count up to 14 without even using my toes. And then I might get their lunch order. That's it. And the doors are usually open when I'm doing that.
And you have bailiffs that sit with the jury or sit outside the jury
They
room?
sit outside the jury room, and usually there's one beside them in the courtroom in case somebody needs something. But usually they'll catch my eye, or they'll catch the judge's eye, and we'll get something handled.
Okay, so did you have any contact with the clerk of court of Colleton County prior to her being elected the clerk of court of Colleton County? Did you know her before she was clerk of court?
No, I did not.
Did you come to know her once she was elected clerk of court?
Yes, I did.
And was it a pleasant relationship?
It was.
And how did you come to be, and to cut to the chase, you ended up being in the courtroom during the Murdaugh trial for part of those 6 weeks. Is that correct?
Yes, sir.
How did you come to be there?
When Becky and I met each other at a conference, clerk of court's conference, where she was discussing that she had that trial coming up, and I knew that she was relatively new, and I said, I'll offer to come help you if you would like. And I think she ended up talking to Judge Newman about it, and they both said, yes, it would be good that I was there.
Okay, because you tried a murder case, two in the past, correct?
Yes, sir.
Okay. And did you go and help Becky Hill try that murder case?
I did. I couldn't go for the first 3 days because I had court in Barnwell, and I told both of them if I had court going on in Barnwell, I could not be in Colleton County.
Okay. To your knowledge, had Ms. Hill ever been the clerk of court that managed a murder trial prior to this?
Not that I'm aware of, sir.
So this was her first murder trial, as far as you know?
As far as I know of this magnitude, I don't know if they had one before then or not.
Okay. Now, when did y'all, I mean, initially, what were you talking about in terms of logistics and how you did it, and all those sorts of things?
Yes, sir.
During that, before the trial, before we ever picked a jury, did she ever discuss with you that she was going to write a book?
Yes, sir.
And
She
did
wanted
she-
to write a book. Yes, sir.
Wanted to write a book. Did she indicate what the book was going to be about?
About the trial?
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what, if anything, did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial, vis-a-vis in reference to the book? What would help the book?
A guilty verdict.
And
Yeah.
tell the judge and me what exactly she said to you that you remember. This is prior to the trial.
Okay. Well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And then further conversations, a guilty verdict would sell more books. And we left it at that. This was before, even in December.
And when did she ever say that again to you during the weeks you spent there?
Several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it.
That she needed a guilty verdict to sell more books.
That would be the best way to sell books, yes, sir.
The best way to sell books. Now, during this process, did she ever express to you an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife?
Yes, sir.
Tell me what she said, and if you remember when.
I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty. And she made a comment that guilty verdict would be better for the sale of books.
Okay. Now, as a result of a conversation you had sometime during the trial, I don't want you to relay to me what was told you. Did you have a discussion with the clerk, Becky Hill, about her being with jurors on her own?
Yes, sir, I did. One morning I showed up to Colony County and I was told that she had taken a juror home the night before. And I was in the courtroom when I saw her, and it was between the pews and where the back row pews are. And I mentioned to Miss Becky, I said, please tell me you didn't take a juror home last night. And she told me, she says, I did, but I didn't talk about the case. I had a bailiff with me. Mr. Bill was with me. I said, Becky, you don't do things like that. I thought we had stopped everything. It wasn't far enough along to really cause a major problem, or I would have told Judge Newman. But I thought we had an understanding that you did not spend time alone with the jurors.
Okay. Now, I'm going to read you some statements. Well, first of all, did you ever hear her say anything in front of you to a juror about whether or not, on the merits of the case, that is, whether or not he was guilty or innocent, or what you should pay attention to? Did you ever hear her, what, if anything, did you ever hear her say to a juror or in the presence of a juror? Anything?
No, sir.
Okay. But let me ask you if you've ever heard her say these statements, and if so, to who? Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understand. Do not be fooled by the evidence presented by Mr. Murdaugh's attorneys. You ever heard her say that?
Your Honor, this time I would object. This witness was specifically called as a Rule 16.3B extrinsic evidence. I think we've covered the two grounds that would be permissible for her to testify to, and I believe that should be the extent of her testimony. So we would object any further extrinsic evidence as improper impeachment and also irrelevant. I think that the issues that were raised with the prior witness have been covered, and that was the express reason that this witness was called, and Your Honor allowed the testimony.
Overruled. You may continue.
Thank you. Did you ever hear her say that?
Can you repeat the verbiage?
Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys.
Yes, I did.
And who was it said to?
It was said to me.
Okay.
And sometimes it might be a staff member in her office or someone from the media there. But other than that, I didn't hear her say it out there in front of any jurors.
Did she ever say to you or to other people around you, I'm not talking about jurors, watch him closely, talking about Mr. Murdaugh. This is just before he testified. Look at his actions, look at his movements. Did you ever hear her say that?
Yes, sir.
Okay. Did you ever have any conversations with the bailiff, Mr. Bill?
Yes, sir.
Did he ever discuss with you the clerk's contact with jurors?
No, sir.
Okay. Did you ever hear her say that the defense is going to try to confuse the jurors? Did you ever hear her say that?
No, sir, I don't think so.
Okay. Now, let me deal with one last area. Let me see if I can simplify this. There was a setup in the courtroom. Pardon me, I've got a little frog in my throat. And I'm fine, thank you.
I think I'll share my bottle over here if he wants part of it.
Once a cork, always a cork. So, and I was there, you were there, this judge was not there. And prosecution tables over here, defense tables over here, judges up here. And then there's a rail behind which the clerk was. And because of all the massive electronic equipment we had there with big screens, there was an area over on my right facing the judge. And then I think you were located in that area right between the judge and that area. Is that correct?
Talking about in the well area?
Yes, ma'am.
Okay, yes, sir. For the
Now,
most part, now sometimes I was out there with the screen
right,
in the gallery.
right. But there was a screen on which you could see not only what the gallery back there could see, but the images that only the jury was supposed to see that were under seal. Is that correct?
That is correct.
Now, there's a woman named Rhonda Ryder, correct?
Rich.
Rich. And tell me who she is.
At the time, we did not know who she was. The first time they were there, we didn't know. Then she came in Miss Becky's office the night before, and she asked if she could have another seat in the courtroom for the next day. And Miss Becky said yes. And she says, and what's your name again? And the only reason why I remember Rhonda, because of course my name being Rhonda. And the next day, Miss Rich was sitting, I don't know how to tell you, but she was sitting. Do you know where Doug was sitting?
Yes, ma'am.
All right. I know, Judge, you don't know where Doug was sitting, but anyhow.
But Doug was the audiovisual guy, and he had access to the unscreened, the unsealed images, correct?
Yes, sir.
And she was sitting right next to him, right?
Yes, sir.
Okay.
In that little part. And
So she could see the body cam, she could see the unredacted corpse pictures, the autopsy pictures, all the photos that the judge had sealed, correct?
well, no, the only thing she could see was what was being put up at the time.
Right. But
Okay.
as they were put up, she could see them.
Right. But they tried their best to seal it where you couldn't, but you could still see it there. I didn't see any of their photos.
Right.
Okay.
But she could see them.
Right. And Doug was really having a problem with that. And I can also tell you that our court reporters didn't know who she was either. Okay.
And she turns out to be a writer, correct?
Yes, sir. After I found out. Yes, sir.
And her name is Rhonda Rich.
Correct.
She was given access to areas that only court personnel should have had access
Right. But then we broke, and then she moved her in the well with me. She was about on my left, and either Elizabeth or Mike was on my right. And I noticed she was taking notes. And I asked her what was she doing, taking notes. She says, I'm a Sunday school teacher. Well, I immediately covered up everything I had.
to. You don't trust Sunday school teachers?
So,
You don't trust Sunday school teachers?
let me just, there's too many preachers in my family on both sides, okay?
So you determined she was not a Sunday school teacher, and later learned that she was a writer writing about the Murdaugh case, correct?
Now, I don't know if she's ever a Sunday school teacher or not. There's just, I don't even know where she goes to church or anything, so I can't tell you that answer. But I did find out that she was a writer because shortly after she was put there, and evidently after I covered everything up, shortly after that, Judge Newman asked for a recess so we could find where people were going to be working. And that's when she put Miss Rich out in the gallery in control of that screen.
And she ended up writing the foreword to Becky's book. Is that correct?
Yes, sir.
Okay. And Becky gave her access to area only court personnel should have had. Is that correct?
That is true. But now I'll be honest with you, sir. There's been a couple times when we had other people that were sitting on that side. We weren't planning on seeing sealed documents that day,
Right.
but there were some other people that sat there, but nobody that actually sat in the well that wasn't court people.
Okay. Thank you, Court's indulgence.
Mr. Waters, on cross-examination.
Thank you, Your Honor.
Oh, okay.
Judge, do you have an extra bottle of water up there by any chance you're willing to share? Oh, Miss Elizabeth Scott, one, thank you.
Ms. McLean, how you doing today?
I'm good, sir. Please call me Rhonda.
I always called you Miss Rhonda. I've known you for a long time as well. In fact,
Yes, sir.
I tried one of those murder cases in front of you years ago. It didn't right.
Yes, sir.
Wanted to ask a couple things. I won't be that long. One of the things that you said earlier is you said when you initially were talking to Miss Hill, she said something like, we ought to write a book or something.
That is correct.
Okay. And so did y'all have any further discussion about you writing the book or participating with the book?
Oh,
or anything
no,
like
sir.
that?
I'm crazy enough not to write one.
Okay. During the course of after the trial, she did send you like chapters and things like that to take a look at.
I did get to see a couple of drafts
Uh-huh.
of the manual.
Okay, so she did send you those to take a look at and review and that sort of thing. Is
Correct.
that correct? Okay. All right. And you were asked and again, Your Honor, just to be clear, I'd made some objections.
You do not waive any objections by cross-examination. They are all preserved. You
Thank you.
may proceed.
Thank you. You mentioned, some statements that you attributed to Miss Hill, during the course of conversations during the course of the trial. Is that correct? Just things like watching closely, watches mannerisms, things like that. And where were those conversations? Were those conversations taking place back in the clerk's offices with clerk staff and people like that?
Yes, sir. In the clerk's office. It might have been downstairs in the bathroom.
Okay.
That some of us had privilege to go to.
All right. So you and Miss Becky and other court staff, maybe just discussing the case and that sort of thing. Is that correct?
That is correct.
And people were expressing their opinions about what was going on and that sort of thing. Is that correct?
Now, when we were having those discussions, there weren't more than one or two, maybe three people there.
Okay. But just a few people there just talking back behind the scenes. That's what I'm driving
Correct.
at.
Yes, sir.
It was behind the scenes, and it's not uncommon for, clerk staff behind the scenes, not to the parties, not to the litigants, not to the jurors, but among themselves back in, in the hallways back there to talk about the day's activities and things like that. Is that fair?
That's correct.
Okay. And that's a big difference between the natural conversations that people that work together, court staff and the like, have with each other and actually having those conversations in front of the jurors, right? There's a big difference between those two, correct?
Yes, sir.
Okay. And it's not uncommon for you. You're a clerk of court. You got people that work for you. Y'all are going to have private conversations about what's going on that are not to be shared, particularly with jurors, but with the public as well. Is that fair?
That
to
is
say?
true.
Okay. All right. And so there were conversations like that going on that you were privy to and part of. Is that correct?
That is correct.
Okay. All right. And you mentioned a little bit about, well, let me ask you this. So there are all these conversations going on, and that's natural. That happens, private conversations with court staff behind closed doors. But you never once saw or observed or had anyone tell you that any of those conversations were being shared by Miss Becky with any juror. Is that right?
That is correct.
All right. And if that had happened, if you had observed anything untoward or improper going on at this particular trial, you would have immediately gone to Judge Newman as part of your obligation. Is that correct?
That is correct.
And you never did that because you never observed anything like that. Is that correct?
That is correct.
Okay. All right. Now, you were asked a little bit about Rhonda Rich, who was a member of the media, and how she was placed kind of back where the defense IT guy was. Is that
No.
correct?
I didn't say she was part of the media, sir.
Okay. Well, she was a writer.
Yes, sir.
Okay. All right, and then you said that, that eventually though, Judge Newman stepped in and then she was moved out into the gallery in charge of the screen out there. So-
Right, but I don't know. I thought Miss Becky moved. I'm not saying Judge Newman did.
Okay, all right, and, over there in that area of the, if we look in the courtroom, there was sort of the grand jury box over here, and that was where, court TV was and media was stationed and that sort of thing. Is that correct?
That is correct.
All right, and inevitably there were media members that could view some of the images that were being shown. They were just not able to report those just because of the nature of where the courtroom was. Is that accurate?
Well, I was told they couldn't see it, so I don't know what they actually saw because I didn't discuss it with the media.
All right, you never had a conversation with court TV or anything like that.
Other than the fact that be careful what they put on my front page of the New York Times on me.
All right. And you're not aware of any image or confidential information or sealed image or anything like that that was ever made privy to Miss Rich that was put in any sort of publication or anything like that. Is that correct?
None I'm aware of, sir.
Okay. Because if you had found out about that too, you would have immediately gone and reported that to Judge Newman because you would have said that's improper. That I need to go report to
That
the
is
judge, correct?
Correct.
And you never once saw anything during the entire course of this trial that caused you to say, you know what, I got to go talk to Judge Newman. Something ain't right about what's going on here. Is that correct?
That is correct.
And you would have done that without a doubt if you had seen that, correct?
Yes, sir.
All right. Now, in looking at, back at this trial, you mentioned that there was a few days at the beginning of trial that you weren't there because you had your own court to take care of back in Barnwell County, correct?
Correct.
All right. And then pretty much after that, I guess you were pretty much present the majority of the remainder of the time. Is that fair to say?
I was. I had one medical procedure done. I missed 2 days, but basically other than that, I was there every day.
And there was a period of time, though, during the middle of the trial where Miss Becky had a medical issue and had to be absent from the courtroom for about a week or something like that.
That is correct.
Okay. And during that period of time, you were present and functioning as the lead clerk of court during that period of time.
That is correct.
All right. So the reality is that you were present for probably as much, if not more than anyone in the clerk's function during the course of this trial. Is that fair?
Yes, sir.
Okay. And again, just to reiterate, there was not one time that you observed or came in possession of any information that you were like, I got to go talk to Judge Newman about this.
No, sir.
Court's indulgence, 1 moment.
Very good. Mr. Harpootlian?
Half,
sir.
half a question.
All right.
Mr. Waters indicated to you that you were not aware of whether or not, and you agreed that you never witnessed her talking to a juror about the evidence. Is that correct? We
That is
agree on
correct.
that. Do you know, but she did admit to you that she had been with a juror alone in a car for some period of time when you confronted her with that. Is that correct?
Yes, sir.
And did she indicate to you what she talked to that juror about while they were alone in the car?
No, sir. She told me, the only thing she told me was that she did not discuss the case, that she had Mr. Bill, the bailiff, with her, and he could tell her that. Tell
Okay.
that.
And when she said she didn't discuss the case, did you bring that up or did she bring that up?
She brought that up.
You didn't say shouldn't be with him because it's frowned upon?
I did tell her that I would caution her on doing that because the perception of dealing with the jurors one-on-one is not tolerated.
Is not tolerated. Thank you.
Thank you, Ms. McElveen. You may be excused.
Thank you.
All right, Mr. Harpootlian, call your next witness.
Your Honor, we would call juror 741.
I know you're not going to. Well, that's right. She's an alternate. That's all right.
We're not going to sign her a letter. We're just going to go with 741.
I got you.
And Your Honor, while she's coming, my understanding is I'm limited to 4 questions.
Yes, sir. I have a copy, and I have given the court reporter a copy of this affidavit with the name obscured and the number, I think, as well. So, but the affidavit that supports this testimony that you're about to offer is Court's Exhibit 5.
Other than a little factual background about her getting picked for the jury and how long she was on the jury and
That's
then she
fine.
got excused. That's all we intend on asking these 4
All
questions.
right, sir.
Unless Mr. Waters asks.
Sure.
more,
I mean, they'll have
And
cross-examination.
I'll be crossing, so.
he
I'm sorry.
will definitely open the door.
That,
So
all right.
he's limited to the 4 questions initially, is that?
Yeah.
No, sir. He's just telling me that's what he intends to do. Sometimes you can hold lawyers to that, and sometimes you can't, Mr. Miller.
Yes, ma'am.
I intend on only asking her those 4 questions.
That's fine. Yeah.
The numbers.
Yeah. I'll talk with the lawyer.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please have a seat. Please stand.
Your Honor, I assume the same rules apply to her that apply to the other jurors in terms of her image appearing.
That's correct. There'll be no photograph made of this particular witness who was an alternate juror in the matter. Thank you.
You're welcome.
I'm going to refer to you as Juror 741. It's what we got to do here, so we don't use your name, so people don't know who you are. Is that okay with you?
That's fine.
And you and I have met before.
Correct.
I came to your home one Sunday afternoon. I believe you're cooking Sunday dinner, and we talked. Is that correct?
Correct.
And then you were interviewed by SWED,
Correct.
and you gave them a recorded statement. And then this morning you came here and you gave me an affidavit that you signed, and you're here with your lawyer. Is that correct?
Correct.
Now, just for purposes of the record, you were a juror. You were selected to be a juror on the State versus Alec Murdaugh murder charge, correct?
Correct.
And you sat in the courtroom for 6 weeks and listened to all the testimony.
Correct.
And you were the alternate.
Correct.
And so when the jury went out to deliberate, you were excused. Is that correct? Now, I'm going to go through a series of questions based on your affidavit, okay,
Okay.
which you signed this morning, which was based on our initial interview with you and your interview with SWED. This is basically the same thing you told SWED. Is that correct?
Correct.
In your affidavit, you say before the defense put up their case,
Object to leading.
Sir?
Leading.
Overruled. Go ahead.
Thank you. In your affidavit, you said before the defense put up their case, Ms. Hill told the jurors, quote, "The defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off," unquote. Is this true? Did Ms. Hill
Accurate.
say
That's
that?
exactly what she told us.
I'm sorry?
That's exactly what she told us.
Okay. The next thing you say is Ms. Hill made the above statement warning the defense would try to confuse us in the presence of all the jurors as we assembled in the same jury room. Is that correct?
Correct.
Now, y'all were initially in
We
two
was
jury.
in 2 separate rooms, and when she came in, we all went in 1 room.
Okay. Paragraph number 5, Ms. Hill said, "If you get emotional, we want to see your face because that is what they want to see." What
She
does
said,
that mean?
She said, don't get nervous. Don't be afraid to show your emotions because that's what they want to see.
Who wants to see?
I don't know who she was speaking of. I'm assuming the court.
Okay. And then number 6, Ms. Hill also informed us Alex Murdaugh was going to testify, but I don't recall exactly what she said. All the jurors were assembled in one room when she made that comment.
Exactly.
She told you that Alex Murdaugh was going to testify.
Exactly.
Did you know before that he was going to testify?
I think we knew that he was going to come up. I think he was supposed to do it the day before, but he didn't. And I knew he was going to be the last person that afternoon.
Okay. During the visit to Moselle, juror number 826 and I walked to the scene together. Then juror 826 began walking with the clerk of court, Becky Hill. I could tell they were talking. I could not hear what was said between them. Is that correct?
Correct.
Is what you put in this affidavit truthful?
Yes, sir.
And this is what you told us back in
I don't remember. That
August,
months
I
ago.
believe. I think I interrupted you cooking Sunday dinner.
Right.
All right, thank you. Please answer any questions defense may have for you.
Mr. Waters, or Mr. Meadows.
Thank you, I mean, please, Your Honor.
Good afternoon, Ms.
Good
741.
afternoon.
It's nice to see you again.
Yeah.
I think it's the first time you talked to Mr. Harpootlian or Mr. Griffin or any other attorney.
I can't tell you exactly. It's been months. It's probably been September, August. It's been months.
Okay. And were they the first attorney to talk to you, or was there somebody else that talked to you prior to them? Any other attorney?
No, I think he was the first person I talked to.
You sure?
I think it was so many people trying to call me, and I was trying not to be involved, so I can't quite remember.
I
But
understand.
he was the first person I seen.
First person in person?
Yes,
Okay. So when he came to your house,
yes,
Mr. Harpootlian came to your house?
yes.
And at that point, was Miss Holly with him? Holly, do you mind raising your hand? You see Miss Holly?
Yes,
Okay. And was anybody else with him?
yes. He was
Mr. Griffin? Thank
Mr.
you.
Griffin.
Thank you. And you gave them a statement then, right?
Right.
And did they record you? I mean, were they audio or video recording you? Did they say we'd like to record this?
No,
They didn't.
but neither did the people that came out. They didn't. I didn't know I was being recorded by them neither.
I'm not trying to fuss.
Oh,
I'm just
okay.
asking. But is there an audio recording of your conversation with them that you know of?
No.
Did they say?
Not that I know of. No.
Okay. So you don't remember saying?
No audio recording. We're required to tell her of recording her under rules. We didn't record her.
He's on cross-examination.
Thank you. And at that point, and that was again, do you remember, you said you think, was that around the end of August, 1st of September when they first came and talked to you? Roughly.
Out roughly. I don't want to.
And you told them basically everything that you've told us now, right?
Yes.
Exact same thing.
Exact same thing that I told them.
Nothing less, nothing more.
Yes.
So Mr. Harpootlian just, and you didn't sign an affidavit back in September or when you talked to him the first time?
No,
And why not?
because he was just coming out to talk to me. He just was asking questions. It wasn't nothing officially. He had, so
When you say nothing officially, I don't know what you mean.
he didn't. He was just coming out to ask. He was just asking questions about what went on during the trial. It wasn't.
But did they ask you to sign an affidavit that day?
No,
Okay. Did they ask you to sign an affidavit anytime right after that?
no,
No, they never asked you to sign an affidavit until this week?
no. I was supposed to meet with them a couple of occasions, but I was having my own personal issues and I couldn't come.
Okay. Well, I'm sorry about that.
No problem.
So you told them at this first meeting, back at the end of August, 1st of September, that y'all going to hear some things that will throw you off. Don't let it distract you or mislead you. Is that what you said?
That's what I didn't say that. That's what the clerk of court told
Yeah,
me.
I'm saying that's what
Oh,
you
yeah.
said to them. I'm
Mhm.
sorry. Okay. And where did that take place?
She would always stand like on the outside of the jury room, like in between, like on the outside. She would never really come inside the jury room.
So there were two rooms, right?
Yeah,
Okay. One room and then the other room
Yoga helps me slow down and focus on my breath. Things can feel too busy sometimes, but my practice helps me find moments for my.
She said that to everybody.
So everybody could have heard.
Everybody could hear it.
And you said you were all in the same jury room.
Yeah, we would all be in the same. When she came, she was standing in front of the door with the jury room that I was in, and everybody would come over. They would let us know before she came, they'll let us know like after lunch she gonna come talk to y'all, and we all would gather together.
So would you go from the two rooms into one room?
Some would be standing out. She would stand in front of the door. Some would be standing around her outside the door, and some would be in the room. But it was clear enough for us to hear and see her.
And I'm just, Mr. Harpootlian led you, and Ms. Hill made the above statement warning that the defense would try to confuse us in the presence of all of the jurors as we had assembled in the same jury room.
We was all in the same jury room. She would be on outside the door, and we would be in the room, and someone would be standing beside her. We was always all together when she came.
And do you think that was unusual?
No, because I guess she didn't want to walk back and forth to room to room.
No, in fact of what she said. Do you think that was unusual?
Yeah, I did.
And if you get emotional and see his face, they want people to see your face?
Because some of the jurors was getting emotional, and I guess she noticed it, so she commented on it.
And you said you didn't, the statement he read, she informed you that the defendant was going to testify, but don't recall exactly what was said.
After,
When was that?
That was, I think he came in that afternoon, like at 2:33. So that was before he testified, I think.
And where was it?
Oh, in the jury room, where we were all, like I said, we would all meet.
And I guess what I'm saying is you're in two different rooms for a while, right? And y'all get up there, you split, don't you?
Yeah.
The people that talk loud in one room and the others in the other one? Pretty much.
No, it's not like that. It was just, they just split it off. They just asked us what room we wanted to go to.
So when you were fixing to come back to the jury room, to the box,
Mhm.
you tell us you'd all go into one jury room together?
Only when she came to speak to us.
And Mr. Harpootlian asked you about, I believe, number 7 on the affidavit. And when did you sign this affidavit?
This morning.
And when's the last time you had talked to Mr. Harpootlian?
No, I haven't talked to him since he came to my house.
Or any of them before today?
No, I haven't talked to him since he came to my house.
Talked to anybody else involved in this case before today, since then?
No, he was talking to my lawyer,
Okay, and who was that?
Sean Wilson.
Okay, and when had Sean Wilson talked to you?
He's been my lawyer
Since when?
since 2021.
Okay, when Mr. Wilson talked to you about this case and what you told Mr. Harpootlian prior to.
All right. They apparently don't object to this, but I am very uncomfortable with your asking what her lawyer told her.
And I wasn't going to time test. I was just looking for timing.
Well, she's told you a couple of times that he was her lawyer since 2021.
Well, see, you're a lawyer for this.
For what you mean for this?
Well, like being a juror.
For being a juror?
Yes, ma'am.
I didn't have he was always my lawyer.
You didn't hire him for this.
No, I didn't hire him for this.
But he had talked to Mr. Harpootlian about your affidavit and your testimony today, hadn't he? Is that a yes?
Yes, he was looking over the paperwork. He was looking out for me because he's my attorney.
When was he looking over the paperwork?
Oh, I guess ever since September, October. I wasn't really keeping up with it to be honest, because I'm.
So do you know if he's talked to Mr. Harpootlian this week?
Yeah, he talked to him today.
Talked to him today?
We was together.
Who was together?
Me and my lawyer.
And Mr. Harpootlian?
Yes, when I went to go sign the affidavit
Okay. Where'd you sign it?
at his office,
At whose office?
Mr. Hopper office. I was supposed to.
I would object.
Okay.
This meandering, I mean, there's no jury here. It's you. And I don't know what this is.
help it a little bit. I think we got all the information. Yeah, all right. I think he's gonna move on. Yeah.
And that's the last question Mr. Harpootlian asked you about this affidavit, isn't it?
What was the last question?
During the visit to Moselle jury, say the number, whatever the letter is, it doesn't matter. You saw a juror, now I walked the scene together, then the juror began talking with the clerk of court. I could tell they were talking, but I couldn't hear what they were said between them. That's the
Correct.
last question he asked, right?
Correct.
So, and you have no idea what that conversation was about?
No, I don't.
Now, the next, number 8, he didn't ask you about was I also overheard discussions in the jury room that Miss Hill drove a juror home. I believe it was a juror whose nickname was Boston. Now, he didn't ask you that a minute ago, did he?
No, but
Just
okay.
yesterday.
No,
And you didn't include that in the first conversation you had with him back in August and September in this affidavit. Miss Holly did you? You didn't tell him about that.
I can't remember.
Have you seen the affidavit Miss Holly did for you back in September 1st,
Objection, Your Honor.
2022?
Ms. Holly did not do an affidavit. Ms. Holly
She
did
just
her affidavit, her notes of what this young lady said to her, and what she included and didn't include was based on what Miss Holly thought was relevant at the time, but she
Yeah,
can't be
that
cross-examined.
affidavit's not in evidence, Mr. Meadows, so I think you need
We'd
to
offer
move.
it, Your Honor.
Sir,
I'd offer it. Just to.
well, how is this thing gonna be authenticated?
You know, even more importantly, he can't question her. I'm sorry.
Several people can't talk at one time. I don't even have the affidavit. Let me see what you're talking. You talking about the one that was just offered today?
This is one Holly did when he first talked to her back in August, and she's referring back to.
Miss Miller. Okay, Miss Miller.
This is Ms. Miller's affidavit about what she thinks this juror said.
Yes.
I'm not gonna allow this, Mr. Meta. I don't see a whole lot of difference between this and what's been said in the affidavit that has been offered by Mr. Waters, but I'm not gonna allow that.
You did not tell them about hearing that Miss Hill had driven a juror home back when you met with them in September, did you?
I can't remember.
Who is Boston?
She was a juror on the trial. I don't know her, but that was the nickname they gave her. I don't know her first name.
And what, if anything, did you know or convey about Boston?
She was a juror on the case, just like everybody else.
Anything else,
Nothing.
ma'am?
No.
So again, Mr. Harpootlian didn't ask you, but when you, in the affidavit of today,
Mhm.
I also overheard discussions in the jury room that Miss Hill drove a juror home. I believe it was a juror whose nickname was Boston. Is that something was added after your lawyer was with Mr. Harpootlian today?
I don't know if I added it. We talked about it today, but I don't know if I mentioned it in September or not.
That's the
But I
first
know
time
it-
We've ever talked about it, wasn't it?
No, it's not.
No reason to raise objection.
The first thing is, Mr. Meadows, I'm going to caution you one more time about this. You cannot talk over a witness. The second thing is you don't need to be marching all back around here. You talking only to me, not jury or anything else. So let's slow down and, this is repetitive of questions that have been asked before. If you want to take this tone with her, I don't know exactly what you're trying to accomplish.
I'm not trying to take the tone. I apologize. She knows that, and I'm sorry.
Well, you're just talking to me.
I'm sorry.
This is not some drama thing for the jury.
I know, I'm sorry.
All right, well,
I'm sorry.
let's
And
finish
Judge,
this thing up.
The only reason I did it, what he hadn't asked about it, and it to me is the key issue here. They're trying to say was different.
Mr. Meadows, I mean, you lecturing to the witness or to me or what? Please don't do that. Strike that from the record, please.
Don't strike.
Let's
I'm so
line
sorry.
it-
I'm
Let's
sorry.
line this up.
I-
All right.
Uh, In number 9 in the affidavit, that before the jury began deliberating, I heard a member of the court staff say the deliberation shouldn't take long. I don't remember specifically who made it, but it was made in the presence of the entire jury right after closing arguments in the jury room.
Correct.
Then I think you said something, Judge Newman came to see you afterwards, but after the jury went to their room, you were in a separate.
No, when we first left out the courtroom, we all went in the same jury room, and then they separated me.
Miss Simply, when I mean to raise my voice.
Oh, that's
You know,
okay.
I apologize.
That's fine.
But when they started deliberating, were you in a separate room?
Yeah, when they started deliberating.
So you had no involvement in the deliberations or verdict of Richard Alexander Murdaugh?
No, sir. No, sir.
You didn't get to come back to the verdict, did you?
No, sir.
Have you read Miss Hill's book?
No.
Okay. And I noticed your interview. I did watch it. And I think Mr. Radford back there, you can raise your hand, kind of, Radford,
Mhm.
I think came to your place and interviewed you.
Right.
At some point during the trial, I think there was some discussion that somebody might have wanted to do an interview with you.
Yeah, that's what she said.
And then after the trial, I think there was some discussion, somebody, since you weren't on the jury, they may not have wanted to interview you. You remember that, roughly telling the officer that?
Yeah, that's not what she said. She came to me roughly in the middle of the trial, and she said, I have a few people who would like to interview. She said, she didn't say a few. She said, I have a lot of people that's inquiring to interview with you. She said, but I'll have to get with you after the trial. But after the trial, she came back in the jury room, and she started handing out cards. And she handed everybody cards but me. And she was like, I don't have any cards for you for an interview because no one wants to speak with you. That's what was said.
And did, I mean, you weren't happy with that, were you?
Yes, I was.
You were happy with that?
I don't need to be interviewed.
Stay course ago.
Briefly, Your Honor. Meadows just asked you a series of questions that I'm not sure I've heard before. Who approached you during the trial and indicated the media would want to interview you?
Miss Hill.
Miss Hill?
Miss Hill herself.
Just you or all the jurors?
They had, I think it's the day they had the bomb threat. And I think that was the day. And she approached me.
You?
Me, by myself.
By yourself. And where were you?
That's the day in the lunchroom when they had the bomb threat. We went to the middle school. I believe that was the day.
The middle school. And she came over to you and said what?
That she had some reporters that was reaching out to her that wanted to speak with me.
To you?
Yeah.
Not the whole jury, to you. Was there anybody with you at that time?
No. It was
Did
just
she indicate why they wanted to speak with you? Just you?
No.
Did she indicate what reporters?
No.
And did she ever talk to you about doing interviews with the media after that?
No.
But you indicated she brought some cards at some point?
She brought cards in to hand to the jurors.
Before?
After the verdict was read.
Cards of media people?
Yes, sir.
Did she tell you she was writing a book?
No,
Did she indicate to you why it might be good for her if you did media interviews?
no.
But she had a conversation with you in the lunchroom of the
I
middle
believe it was the
school.
lunchroom. I
by-
think the day of the bomb threat.
The day
But
of the bomb threat.
I'm 100% sure she came to me and she told me that in the middle of the trial.
Was there a bailiff with her or just
No.
her?
It was just her.
Pulled you over and said, hey, I can make you famous. I can put you on TV.
She said she had media that wanted to talk to me. That's what she said.
Okay. I hyperbolize. I apologize, Your Honor.
Yes, sir.
That's all I have.
All right, no further questions, Mr. Harpooly?
No, Your Honor.
Very good. All right, thank you very much, ma'am. You are excused. All right, Mr. Harpooly, that it?
I need to put one matter on the record, Your Honor, and that is it.
All right,
As soon as I'm told what to put on the record.
all right, sir.
Just want to talk to her after that to make it part of the record. Your Honor, earlier today, you received a very short affidavit from Juror Z. We'd like to proffer that and make it part of the record.
Right, I did not admit it, but I'll accept a written proffer, and if you would give the thing to me, I saw it on the screen on my law clerk's computer, but I don't have a printed out copy.
We don't either, but would you allow us to do that?
I will allow, before I close the record with Ms. Harris, if you can get it to us. When can you get it to us?
We can email it this afternoon.
Very well. How about do this? How about email it to Mr. Waters, to me, to Ms. Diaz, and to Ms. Harris, the court reporter. And I will say now that it's offered as a proffer, and I will receive it as a proffer. I have not admitted it into evidence.
Yes,
All right.
Your Honor, we referred to earlier on a email to the Japanese television folks. I do have copies of that. I'd like to make that part of the record.
All right, but hand it up to me and let me see it. And also, of course, to Ms. Waters. All right.
And Your Honor, for the record, the hearing before Judge Newman to seal the body cam videos was on May 26, 2023. This email is in July, just to give you the context of
All
what's
right,
going
and
on.
this is being offered as a after the fact email to Rebecca Hill, and her replies garnered from the emails that were released by Cotton County at a certain point. And it addresses the issue I raised with Ms. Hill relative to the security of sealed records.
Exactly, Your
All right,
Honor.
I'll admit it. Mr. Waters?
As to this specific exhibit, Your Honor?
Yes.
Your Honor, I mean, we don't have any objection other than the ones we've raised just generally to the testimony. But I have no further objection to.
Very
Your
good.
Honor,
All right.
And Your Honor, that's all we would have.
All right, hang on. All right, have you got a copy of it there? I got it. This is his next exhibit. Proffer is his one. Right. Your the proffer is your exhibit one, Mr. Harpootlian, and this, which I have admitted, is your exhibit two.
Thank you, Your Honor.
All right. All right. Now we proceed to closing. You prepared?
Yes, ma'am.
Very good. Mr. Waters.
Thank you, Your Honor. Just to go back and reiterate as to the standard, and ultimately, we've of course argued that the defendant has the burden. We've also discussed that the standard for Your Honor, of course, is first of all, was there any misconduct that occurred? And then regardless of that, whether or not there was any effect on the verdict. And the standard has been expressed in multiple cases is whether the verdict is solely the product of honest deliberation or the product of outside influence. And that inquiry fundamentally, as the court recognized from the very beginning, focuses on the jurors themselves, because it doesn't necessarily matter what was said as much or what was intended or what was inadvertent, even assuming that those existed. What matters is what the jurors heard, what they perceived, and whether or not it had any sort of effect on the verdict. And Your Honor went through that inquiry with these jurors. 11 of those jurors were clear and unequivocal that there was no effect on their verdict, and also clear and unequivocal that nothing was said that could in any way be inferred as any sort of attempt to influence them. And I think that's very important, Your Honor, because there can be sometimes behind the doors, as we've talked about, I think some of the cases recognize this, that some conversations can go on and things like that can happen. But ultimately, and while I think there were some cases cited in some of the various South Carolina decisions, that's unrealistic and not surprising to think that sometimes things like that can happen, an untoward comment or something was said. But that was an Aldrich, Your Honor, in the 1999 Supreme Court case. But the mere fact that something like that may be stated, that could be stated in a neutral reason, is not enough to undermine the verdict, because the inquiry ultimately boils down to what was it that those jurors heard, and in the end, though, did they listen to the instructions from the trial judge? Did they come to a fair and honest verdict? And Your Honor, the evidence here is overwhelming, I would say, from the people that matter, and that's those jurors. And that is, there was no effect on the jurors. And you saw every single one of them very clearly and strongly looked you in the eye, all 11 at least, and I'll get to the 12th one in a second, but looked you in the eye and said, no, that didn't happen. No, I didn't hear anything like that. No, there was no effect on our verdict. No, this was our verdict, and it was based solely, which was Your Honor's question, solely on the evidence and the law and the testimony at trial. And I think that carries the day. We have the one juror, and I want to make sure, because I'm about to say the number and I don't want to do that. Let me go back to Juror Z. And let's look at Juror Z and what she said, because Juror Z also said that, yes, I said this was my verdict. I was polled and said this was my verdict. Juror C also said that my verdict was solely based on the evidence and the law, the testimony at trial. Answer question number 2, yes. Absolutely, yes. But then goes on after that to say she heard some communications from the clerk, and then says, well, it had an effect on my verdict. Even after she had already answered question number 2, when she said her verdict was based solely on the evidence and the law and the testimony at trial. And beyond that, then, Your Honor, I think that it's very telling that the affidavit that was submitted from this particular juror, and we've been pointing this out from the beginning because it's very crucial and very telling, because despite the things that she alleges that happened, even though the other jurors say it didn't, despite the things that she alleges that happened, she says that she voted guilty because she felt pressure from other jurors, not that her verdict was in any way affected from some supposed external influence. In that affidavit that was filed with the defense motion from day one, that is what
she says that she felt pressure from other jurors. And Your Honor, we've cited the cases over and over again that the internal mechanics of the jury room, the fact that one juror feels pressured by others, as long as there's not violence or things that go beyond the pale, that is not a basis for undermining a verdict. That is part of the deliberative process, and it's expected, and it occurs. But I think it's very telling that we have those conflicting answers. And Your Honor, without waiving any objection to the latest affidavit that we were just discussing from this juror, I think that's very telling, because now we have answer number 3 as it relates to this particular juror. And of course, it is clearly manufactured and rehabilitated, recognized after the fact. She, of course, is this juror is represented by Joe McCullough. Ultimately, we've got now a third version of events from this very juror. So we have this juror who's given answers all over the place that are inconsistent with 11 other jurors who were very strong and unequivocal that, yes, this was our verdict. It was based solely on the evidence, the law, and the testimony, that there were no communications from Becky Hill that influenced that verdict. And I think ultimately when you look at the case law, in the end, it's up to Your Honor to make that ultimate determination and looking at all that law together. We cited a number of decisions, including, as we discussed, the questions to be had. I sent an email where we set out some questions that it's not uncommon, perhaps, for a juror to have a second thought. But the law is very clear that it does not recognize that, because what that would do would be to consistently and constantly put every verdict that occurs in any courtroom in this state or in the nation at risk. Jurors don't have to vote in perpetuity. They vote on one day and one day only. And here, Your Honor, the evidence is overwhelming that those jurors' verdict was the product of honest deliberation. And the only bit of contrary evidence to that effect is from a juror who, frankly, not only said that it was purely the result of honest deliberation, but then has answers all over the place. And Your Honor, I would say that the other 11 jurors are credible. They were strong. They were clear with Your Honor. And I think that ultimately that carries the day. Now, we've had testimony from other people since the jurors were here. We've had testimony, obviously, from Ms. Hill. We've had testimony from Ms. Rhonda. And we've had testimony from this alternate juror. But again, none of that testimony at all goes to what is the ultimate test for Your Honor, and that is whether or not this verdict was the product of honest deliberation. And on that, again, the evidence is overwhelming and strong and clear that it was the product of honest deliberation. It's very interesting as we look at some of the testimony from the other witnesses. And obviously we have Miss Becky, and as Your Honor has pointed out, we're not here to go through some of the issues that have been alleged or are percolating out there. That's not the point of this proceeding here today. But Miss Becky is a court reporter and then became a clerk, and was clear to you that she never made any comment in an attempt to sway the jury one way or the other. We have Miss Rhonda. And Miss Rhonda came in and testified, but I would submit to Your Honor that this is kind of a red herring, because what Miss Rhonda described were conversations that she herself admitted are just the kind of conversations that go on. And that's the reality of it. The conversations that go on among a trial team when we're not in open court, where we're discussing things, the kind of conversations that go on among court staff behind the doors, those types of conversations go on. But that does not mean, nor does that necessarily indicate that somebody's not going to come out here and do their job fairly and understand the distinction between influencing a jury and not doing that. And one thing that I think is very important is Miss Rhonda was at that trial more than Miss Becky was. And she was very clear
And I probably was as repetitive as anyone here today in asking that question over and over again because I didn't want that point to be lost. That Miss Rhonda said I was there more than anyone else, and I never saw anything or observed anything or had anything happen that would cause me independently to go to Judge Newman, because that's what I would have done, to go to Judge Newman and say, something's not right about this. This needs to be fixed. Something's going on that's improper. And I think that that is an extremely crucial fact because Miss Rhonda admitted and said, of course, as she would, that if something had happened that the judge needed to know about, she would have been the first one to do it. And it never happened. And she was here more than Miss Becky was. It never happened. When we look at the balance of those facts, when we have the clerk of court come in and testify that, you know, maybe I did this or maybe I did that, maybe I plagiarized the book, a portion of it, maybe I did this, maybe I wrote in things in there that are based on community knowledge or newspapers or poetic license or whatever you want to call it. I don't care about the book. And I would submit that Your Honor doesn't need to care about the book either, because the book and what happened with the book afterwards is not what is relevant to the inquiry. But she was clear that she did not have any attempt to influence that jury. She was clear about that. And Miss Rhonda was clear that she was not aware of anything like that either. And what does that do but corroborate the most important witnesses here? The defense, I think in one of their letters, tried to say that Miss Becky was the state's star witness, and that's not what this inquiry is about. It's not what this inquiry is about at all, because as I've said from day one, if there were not facts to be litigated, if we had not done an investigation and had those 11 jurors say, that didn't happen, there was no effect on our verdict. This was the product of honest deliberation. We would be the first ones here standing here to say that. But what we do know, Your Honor, is that what Miss Becky said and ultimately what Miss Rhonda said corroborates who are the true, if you want to say it, and I'm only using this term because the defense accused us of Miss Becky being our star witness. There are no star witnesses here. This isn't about stars. But what Miss Becky and Miss Rhonda do is corroborate who are the most important witnesses. And that are those jurors. And you have 11 of them strong as a rock saying this verdict was not influenced. Nobody tried to influence. And regardless, it was the product of our honest deliberation. And you have one juror who said that too, but then has answers that are all over the place. And if you go back to her original statement, what she says is not external influence anyway. It's not sufficient under the law. So I think that the proof here is overwhelming. I think the proof here corroborates what those jurors say. I think the only juror that we have to contend with, her testimony is compromised. And I'm not saying that that person is in here maliciously lying. I just think that this process is a lot. But it's clear that if there was any attempt to influence this jury, those jurors who sat in that box, every single one of them, you saw them, and we saw them for 6 weeks. They are conscientious. They take their obligations seriously. They were not here to reward friends or punish enemies. They were here to do their job appropriately and fairly. You saw that in their eyes. You saw that in their mannerisms. You saw that in their demeanor. And they were strong and clear that this verdict was fair. Your Honor, we would submit that the motion for new trial be denied.
Mr. Harpootlian.
Mr. Griffin will be arguing.
All right.
That's good. Okay, if I stand here, Your Honor. That way I won't be interrupted by Mr. Harpootlian as I'm trying to make my points. Your Honor, I want to first start with State v. Green because I understand that that's the guidance. That's what we're following here. And reading, excerpts from State v. Green. First, it is absolutely clear in State v. Green that we find ourselves, and the issue is whether there's a defendant's right to a fair and impartial jury under the Sixth Amendment has been violated. Reading from the opinion, it says, in the Sixth Amendment's context, the Supreme Court of the United States has held that, quote, any private communication, contact, or tampering with a jury during a trial about the matter pending before the jury is deemed presumptively prejudicial. Now, Green goes on to say that we are not going to categorically apply the presumption whenever there is a contact with the juror. But the question is it prejudicial? Not whether the verdict would have been different. It is it prejudicial? And I'll keep reading. The court says, we're not persuaded that the Rimmer presumption of prejudice, we're talking about prejudice, not is the verdict different? It was their prejudice. Was this tainted process? Was it prejudice to the defendant? Was the process prejudicial to the defendant because of extraneous communications? Not whether the verdict would have been different, but whether there's prejudice involved in the process of the trial. The court goes on to say, our unwillingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. Goes on to say the attempted bribery of the jury in Rimmer conduct, which goes to the heart of the merits of the case, is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. The court says, while we decline to adopt the Rimmer presumption of prejudice in every instance of inappropriate bailiff communication to a juror, the occasion of this case presents an opportunity for our clerks of court and circuit judges to ensure that all bailiffs are properly trained. Now, the only thing the Green did was reject the presumption of prejudice in every case. And Your Honor, I just want to preserve for the record that our position is that the comments that you heard in this case go to the merits, go to the heart of the defense. And if you find that those comments were made, and I'm going to establish for the record, we clearly have proven that then we do get the Rimmer presumption, that we do get the Rimmer presumption if we have proven these comments were made. But I'm going to argue that we prove prejudice also in this case. So to start with, let's go to the evidence that was presented since Friday. And Your Honor, we have 12 deliberating jurors. In this case, what you've heard, 3 of the 12 have testified under oath that they heard Ms. Hill make comments about the case, whether it's, how they categorize it as merits or not. But Juror X on Friday acknowledged that Ms. Hill made a comment about Alex was going to testify, that it was going to be epic or some words like that, and that defendants don't normally testify. That's what Juror X said on Friday. Today, so that's one who says Ms. Hill made a comment about Alex's testimony, how it's going to be a big deal, and defendants don't normally testify. Juror Z today says that first she says Ms. Hill said to watch his actions, to watch him closely, and then she said there are other things that he said I don't remember, and then we were allowed to show her, and with Your Honor, I asked her questions about her affidavit, and she says, confirm what was in her affidavit, that Rebecca Hill told the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also acknowledged, this is a truthful statement, that she instructed the jury to, quote, watch him closely, close quote, immediately before he testified, including look at his actions and look at his movements, which I understand to mean he was guilty. And she also said and confirmed that Ms. Hill said when they began deliberations that this quote, this shouldn't take us long, close quote. And that if we deliberated past 11 p.m., that we'd be taken to a hotel. Those statements go to the merits. Those statements go to the heart of the defense. Those statements go to what Mr. Murdaugh, his credibility. So that's 2 deliberating jurors down. The 3rd deliberating juror who testified today is Juror P. And he says, you were asked, Juror P, did Ms. Hill make any comments about the case? And he says, yes. She said the day that Alex was taking the stand, excuse me, Juror P is a he, but he is saying that she, Ms. Hill, said the day Alex was taking the stand, that she, Ms. Hill, made the comment about watch his body language. That's all I recall. So 3 of the 12 deliberating jurors heard Ms. Hill speak about Alex Murdaugh's testimony. 3 of the 12. And then we get the alternate juror came in and basically corroborated what those 3 of the 12 heard. And she had additional things that she had heard, but she corroborated what those 3 of the 12 heard. And then you've got Ms. Hill who gets on the stand and denies it all. And Your Honor, I couldn't agree with you more that you're able to judge the credibility of witnesses. And on this record, there's no way to find Ms. Hill credible. There's no way to credit her statements that she did not make these statements about his testimony. I mean, she crossed herself up as Your Honor is questioning her about the transcript involving the egg lady and how the egg lady learned that there's some Facebook post that was allegedly attributed to her husband. There's no way the egg lady would have known that unless Ms. Hill told her, and that pretty much came out there. I mean, so, you know, and I know this is not a jury argument, but if someone misrepresents a fact to you once, I mean, I don't think you should go back and credit anything beyond that. What we hear from Ms. McElveen is that she heard these almost identical statements from Ms. Hill that Ms. Hill told that 3 of the 12 deliberating jurors heard, and the 4th alternate heard. That Ms. McElveen heard her make very similar statements about the defense's case, about Mr. Murdaugh's testimony. So you got to put Ms. McElveen's testimony in our category. And Ms. Hill gets up there and says, never drove a juror home. Ms. McElveen's got no dog in this fight. And she says, she goes to court one day, she hears that Ms. Hill took a juror home the night before and went and talked to her and said, you can't do that. And Ms. Hill said, I didn't talk to her about the case. Well, she gets on the stand under oath here and tells you, I never took a juror home. I mean, it's totally inconsistent. And for her to say, I never made these statements, you know, she tried, I mean, she kind of gave herself a little wiggle room at the end. Well, when they were lining up, I may have said he's going to testify today or something, but these jurors heard this information. And the question under Green and Rimmer, was it prejudicial? Now, what we got from Juror Z today, the question was, did these comments influence your verdict? And Juror Z says, yes. Then you ask how? And Juror Z says, to me, it felt like she made it seem like he was already guilty. Then you said, did it affect your finding of guilt in this case? And the answer was yes. And so that's prejudice, Your Honor. That is prejudice from one of the 12 deliberating jurors. Was your verdict influenced by what Ms. Hill said? And good grief, how could it not be? How could it not be? And to ask all these other jurors who heard the same thing, was it influenced? It's really an impossible task because you don't know what's influencing a jury. And frankly, that's why the Rimmer presumption is there. But let's try to sort this out. And Your Honor, I think it was a State v. Kelly case where the deputies went out and they were investigating the jurors' beliefs on the death penalty. And there was really no testimony about, did that affect your verdict? But it was just so wrong. The conduct was so wrongful that the Supreme Court says that's prejudicial and we're granting a new trial. I mean, this is prejudice. And this has been proven. I mean, Ms. Hill is not credible. Ms. Hill is not credible. And she's talking about her book, talking about taking literary license to lie. Literary license to lie is that's what she thinks a literary license is. So her testimony should not be credited. We have proven, we have met our burden of proving that there was extraneous contact with these jurors. 3 of the 12 deliberating jurors have testified to that. 1 of the 12 says it influenced my verdict. How is that not prejudice? And that's all we have to prove. We believe, for the record, there is a presumption of prejudice that they have to overcome, but we have proven prejudice. And Your Honor, we respectfully request that a new trial should be granted based on the record developed today. Thank you.
All right. The arguments are closed. I will take until 5 of the hour to examine my notes, and then I will come and make a ruling from the bench on this matter. Court will be at ease.